morning. Today we are going to look into mediation as an effective alternative dispute resolution. An alternative dispute resolution is an outcome of all such problems which we are facing by the public constantly in litigation. It is like a substitute. So it is like a substitute, like what we would say, to the traditional method of resolving dispute and justice. So an ADR mechanism mainly focuses on delivering justice through mutual consent of the parties in the minimum time without delay, like in any litigation. So an ADR mechanism recognized four methods to resolve any dispute such as arbitration, conciliation, mediation, and negotiation. Alternative methods are work on the mutual consensus and try to settle dispute with as early as practicable. Alien mechanism is an option to the public who do not want to go for conventional method or want to resolve their matter without court's interference. These mechanisms have their own advantage as well as flaws like any other persons have might do. Yet, particularly in the context of the mediation, it needs emphasis that it is the only one of the important objectives. Mediation is a processual intervention in the legal system, fulfills other instrumental and instinctive functions as an equal, and it is not of greater importance. So, in its instrumental function, mediation is means to fulfilling stated objectives. The intrinsic function of the mediation emphasizes the value of mediations by the end of itself. Now, mediation in India. Let's look into that. So, in India, the law and the practice of the private and the transactional commercial disputes without court intervention can be dated back to ancient times. Arbitration or mediation as an alternative to dispute resolution by municipal courts has been prevalent in India from Vedic times. These arbitrary bodies, known as panchayats, dealt with variety of disputes such as disputes of contractual, matrimonial, and even criminal in nature. Now let's look into the principles of mediation. Every process of ADR has its own basic principles. So in generally, there are 5 basic principles usually seen in mediation. And the first one is parties should participate voluntarily. Second one is confidentiality matters in the process. Third is mediators are impartial. Fourth is an agreement has to be settled with the satisfaction of the parties concerned. And lastly, it is mediation is without prejudice to other procedures. So that is what is the 5 essential ingredients of mediation. So there is no necessary interference of the court in ADR techniques, but yet its different stages would discharge some important functions. The mediation is not just adjudication of cases, but in the settling dispute. Mediator is also not allowed to adjudicate, but can only try to settle disputes or could communicate with the parties. I hope you understood what is mediation in the ADR aspect. Thank you so much.